Yeah. Good morning to all of you. Everybody's out there angling for a good morning. Good morning, Jules. Good morning, Angry Dog. Good morning, Uncle Pat. Good morning, Customer States PNW. Good morning, Vietnam. Good morning, Mike. How are you?
Morning, Norm. I'm doing well. Staying hot,
Well, it is a little bit. It is a little bit of a musty week. Hey, a programming note. We're going to miss. I have to miss Wednesday and Friday. My wife has been lined up for some significant surgery, and we've got medical appointments. And being the good spouse, I'm going to be with her. So I know yesterday, Mike, you said we'd be on the rest of the week. I forgot to tell you that I've got some stuff to attend to, and everything will be fine, I'm sure. But it's the right thing to do. Odd world in Julian Assange land. I was sort of surprised by this. I expected the United States to bring Assange back. I expected them to give him the J6 treatment and fit him for a cell for life. Mike, what happened?
So the Daily Wire reports, and I don't know what happened. So I've asked the question here on the screen, and I stopped short of just asking the question explicitly. But is this how desperate the Biden administration is during the election season? That rather than doing what you just said, after I guess I look historically, what is the point of having held out and applied so much pressure for so many years, only at the last minute, whatever became the last minute, to say, will accept a plea for your alleged violation of the Espionage Act, and on a common set of facts and circumstances under which Bradley Manning, later Chelsea Manning, served 7 years in prison, right, and then had the sentence commuted by the Obama administration. So this is interesting, right? We appear to be on the precipice of a hot global conflict. Tensions are rising all over the place right now, and this impacts the integrity of the U.S. surveillance and security apparatus, which seems right now to be very top down and very heavy in a domestic capacity, at least. And then, the poster child for this, there's been plenty of calls from the journalistic community to pardon Assange, and I'm not taking a position one way or the other. I'm just interested on what you believe, Norm, the DOJ's basis would be for accepting a guilty plea from Assange right now. And he won't see any jail time, according to the reports. He's not going to see any jail time. It'll be time served.
Yeah, my understanding is, and I read the Daily Wired report because it's so ideologically driven. I went ahead and looked at a few other reports, and it appears that he is going to be given credit for the time that he spent behind bars, either in England fighting extradition, and
it was I think it was behind bars though, and that was within that piece as well. So 62 months in the UK. I think it was on house arrest.
And so he gets credit for that. He gets to return to Sweden, case closed. Presumably, he's a persona non grata in the United States. I think I thought, frankly, it's an election year move. I was going to, and I was pleased to see it. I wanted Assange not to be returned to the United States and locked up forever. So I'm cynical about the motives, delighted by the outcome. But it does strike me as an election year move. You can't pardon your son, but you can kind of give an effective pardon to Julian Assange. I don't know what more to make of it than that, frankly, but I was surprised by it.
Yeah, I mean, sorry to be so cynical, but that it appears clearly to be that, and that's why I said, is the Biden administration currently, in its current state and form, desperate enough to have done this, especially considering the way that the DOJ is prosecuting American citizens in its current capacity. Right? It just seems like a clear departure from the pattern of conduct and what we have, come to know of this Department of Justice and its priorities, especially with respect to the institutional power that it wields. This clearly. I wonder if the American voter will see through for what this actually is.
I sometimes wonder what the American voter sees at all. I mean, especially during the summer months, the campaign won't heat up until, again, after Labor Day, although we've got conventions coming, and next month soon, I think July 11th, Juan Merchan will sentence.
An alleged debate tomorrow or Thursday.
That's true. Well, right? Do you intend to watch it?
I don't know. I haven't decided.
I have not. I have not watched presidential debates in years on the theory that I didn't want my good night's sleep discomfited. But I might tune in on this because I saw on Mike Smirkanish's show the protocol, and apparently they're going to have hard stops on the candidates, and strict time limitations: 2-minute openings, 2-minute closings, a minute to answer. And if you speak beyond the moderator's brief, as it were, the off button will be turned. And that in and of itself should be interesting. I think Smirkanish had an interesting perspective, which was the bar has been set so low for Biden that he can't help but come out looking well. Apparently, last week there were a bunch of loops of him stumbling verbally around the world. Let's see what happens. I'm going to probably watch it with a scorecard, and I'm not going to try to give style points. I'm going to try to ask myself, what are they really saying about the world, and what are they promising to do in the world we all inhabit, and does one stand above the other or below the other in terms of preferability? I'm going to try to keep an open mind, and I guess I won't be reporting on it on Friday morning. I'll be in the hospital with my wife, but I'm sure, Mike, you can report on it, or we'll get to it on Monday. So,
Sure thing. Sure thing. We'll see. I know that from, I think it's being moderated by the glowing network CNN, right? So I think they're sending the CNN team there. Trump agreed to that, which I believe has drawn a lot of criticism from within his camp. But we will see. I mean, I think that the restrictions being imposed on and the rules and the rigidity being proposed, they all favor Biden. They favor small sound bites. They favor not talking over one another. They favor the fact that it is essentially a sort of a fixed fight, right? We want and that's clear, right? So however long the drugs will last for Biden is how long the debate will last.
So what do you think? What becomes of Julian Assange? What's in his future? Does he get an endowed chair at a Swedish university? Does he reemerge as head of a public interest group? Does he go silently into the night? He's been awfully quiet in years past, and I just don't know what happens next.
I read at one point in time about the deterioration of his physical and mental health. So not just the mental health of being subject to um, extended periods of lockdown, et cetera, et cetera, et cetera. For a time he was he in the Russian embassy there?
I thought it wasn't the Ecuadorian
Well,
embassy.
he spent time in the Ecuadorian embassy, but certainly he was at one point in time a piece of political capital on the geopolitical stage.
Hmm.
And I wonder how much of the Julian Assange that got him to this level of fame or notoriety, depending on how you view this, is even left, Norm,
Hmm.
to be honest
Hmm.
with you. I worry that I don't necessarily lose sleep, but I think I observe that he is probably going to go somewhere and be unseen for a while.
Well, God bless him. He's lived in the world's limelight for a while, and he's paid his dues. I wish him nothing but peace in life to come. Hey, if you live in, and I'm not sure I'm pronouncing this correctly because I am from the Northeast and Mike is from the Southeast. Llano County, Lano. Is it Llano or Llano in
Yeah, what we're
Texas?
trying to decide is whether that double L actually means anything in the context of a county designation. Is it Llano County? Does anybody know? Llano or Llano?
Give us a tutorial and we'll take it up. But here's bad news for readers in the public library there. As a result of federal court action, several books are now being removed from the shelves. And I'm talking about such classics as Larry the Farting Leprechaun and I Broke My Butt. These books have been removed under the imprimatur of the First Amendment in the context of a larger and significant context. Obviously, librarians curate their collections. There are only so many books, spaces for books on shelves, and as librarians cull their collection, they typically they use something called the musty criteria, the musty factor, mustie. Does a book contain misleading or factually inaccurate information? Is it ugly, worn out beyond mending or rebinding? Has it been superseded by a new edition or a better source? Is it trivial? of no discernible literary or scientific merit. And don't tell me that a farting leprechaun is trivial. Is it irrelevant to the needs and interests of the community, and made the material be found elsewhere? And so, the problem of de-accessioning books, that's what it's called, places considerable discretion in the hands of librarians. What this Fifth Circuit Court of Appeals decision said is that among the musty factors, there cannot be consideration of the content of the material. In other words, you cannot remove a book so as to deprive a member of the community of access to an alternative point of view. So, among other books that were removed with "I broke the classic." The classic "I Broke My Butt" and "Larry the Farting Leprechaun." There were 4 young adult books touching on sexuality and homosexuality, such as "Gahi, a Girl in Pieces," "Being Jazz, My Life as a Transgender Teen," and "Freak Boy," both centering on gender identity and dysphoria. Elizabeth Williamson's "Caste" was removed. They called themselves the KKK. Was removed, and a well-known picture book, "In the Night" by Maurice Sendak, which contains cartoons of a naked child, was removed. It's perfectly normal, changing bodies, growing up, sex, and sexual health. So some of these books were removed because, in the judgment of the librarian, of the library board, or of certain patrons, they represented viewpoints that either patrons or the librarians were uncomfortable with. A group of parents brought an action for injunctive relief, that is, a court order to stop the library from removing those books and ordering them to return them, by application of something like the musty factor. The Fifth Circuit weighed in and ordered certain of these books returned, including Elizabeth Williams' "Caste" and others. It raises questions about local control of libraries, and it raises questions about access to information. It's a sort of surprising decision on my in my view. When I go to a library, I want to read books that challenge me. I make a practice of reading books that are contrary to what my expectations of the world are. So, for example, I recently read the book "Sedition Hunters." I think it's Patrick Riley. I can't remember his last name. And this is a book about the group of citizens who made it their business to track down people who participated in the January 6th insurrection or riot. At the time that I was trying the Proud Boys case, I was aware of sedition hunters and regarded them as the enemy, as most of us did in the trenches. I wanted to find out what motivated these people. I wanted to find out what techniques they used. I wanted to find out how broadly the government relied on them for its support in terms of prosecution. And I learned, for example, sedition hunters had a pivotal role in the Proud Boys case. Late in the Proud Boys case, Zach Rell, who's a client of mine on appeal, testified he'd not engaged in any violence against officers. And over a long weekend, sedition hunters got into the government's hands a video of a man who appeared to be Zach spraying bear spray at an officer. And that late addition to the case, that late disclosed evidence, cost Zach dearly in terms of his sentencing. So I view libraries as sources of contrarian information, and I don't want librarians having the ability to say that I can read this and not that. On the other hand, I'm not sure I want the courts telling librarians what standards they should apply, and I'm not sure what the answer is. I mean, what's your view, Mike?
It's a great question. I'm fighting the urge, and I'm going to lose here because I'm still going to mention it, but fighting the urge to go down a rabbit hole regarding how relevant public libraries are or are not in 2024. Just don't have a read on how frequented public libraries or even the Llano County Library is, and whether those involved in this lawsuit, namely the parents or the adults that were checking out these books for months on end to prevent any other people from being able to check them out. Whether they are representative of a larger class of people. Now, don't hear what I'm not saying, Norm. I certainly understand that this is a very sensitive topic on both sides of the political aisle, a very partisan issue right now with respect to books in school libraries. In particular, this is not a school library, this is a public library. And I think I draw a distinction there, Norm, between content and information available in a public library, because we're talking about um, young people exclusively, especially elementary, middle school students, and that which is available in a public library, for which someone can have a library card and can go and can sit. I tend to have that very um, maybe sort of naive sensibility that public libraries still occupy this place where anyone has access to information without restriction or limitation, and that I think compels me to think little or less of the people who brought this lawsuit, even if I disagree with the content being available in certain libraries. We're not talking about Barnes and Noble. We're not talking about a school library. We're talking about somewhere that should be chock full of even dusty collections. Those that are, I know that there's a whole culling process or a weeding process, as they call it, to pull off books that maybe are just occupying space that never get picked up. I even kind of disagree with that. I feel like there should be some sort of warehousing or inventory that is still accessible to the public, but just isn't displayed within the shelves and like organized. Perhaps if you just want to go on a discovery, I do think that the world is not so different just because we are so technologically inclined and surreally online these days from 10, 20, 30 years ago. And I also think that books are a great place to find history as it was written at the time, as a comparison for how history is being written now. And that's, the cultural parlance of fiction writing versus, the way that facts and narratives were drawn in the history books, objective nonfiction pieces. And even if we step back and look at these titles from a 30,000-foot view, sure, I think the availability of them it's a statement in and of itself, right?
Yeah,
A
yeah.
cultural statement, and to that end, I think people being afraid of the content within these pieces is a problem. I think it indicates a certain level of societal and cultural discord, right? And that the zeitgeist has gone somewhere that we are not familiar with, at least in our current day and age. So I think, long-winded way of saying I disagree with the court stepping in this capacity. I think that there's also something culturally broken there in Llano County, and perhaps it is a certain fear of this type of content and its relationship to what most people fear is preying on young people online as well.
Had the court not intervened and the book's been kept off the shelf, would you have been satisfied with that?
I don't know. Like I said, I know so little about the administration of public libraries. I'm thinking just theoretically, books should be available. Uh,
Yeah, that's my view.
and,
I
and
I
I understand that the way that they are curated. Again, that's why I said something about Barnes and Noble, right? You can go by any Barnes and Noble or any sort of bookstore that has a certain political bent, and you will see things curated and arranged such that the most valuable visual real estate is given to certain titles that millions of people in the country would not agree with, right? That's not what I'm talking about here. I'm speaking purely to availability, and then
Yeah,
sort of
no, I hear you. I hear you.
decimal system in terms of organization, not trying to push things and people in certain directions. I think a more objective criteria for organization is necessary. And to that end, I think that the library should be free. I don't know how Llano County even appoints or elects or, administers its public library, system. So the people that are there are those that are available and also willing to do the job of being librarians. So yet another call, Norm, for me to say, if there are things that you care about in the world, civic or otherwise, it is incumbent upon you as the individual to put yourself in that position. So anyway, off my soapbox.
I loved the stacks at law school. The stacks was where
Yeah, yeah.
they stored books that, didn't often get referred to. And I remember finding a copy of the trial transcript of the Chicago 7 trial. And no work got done that week. I read that book as though it were my destiny, and of course it wasn't, or maybe it was in some respects. But books off the beaten track, I think, are the best. And I think that a library and a bookstore has a duty to express as broadly as its stacks can the full range of human experience and let the reader make their choices. I just don't like the community intervening and saying you can read this and not that.
Well, and again,
It,
there's a certain sort of passé element to the existence of public libraries right now. I'm in no way advocating that they go the way of Blockbuster. Shout out to Customer States talking and making the parallel between libraries being the new Blockbuster videos in terms of the antiquated nature of that tech or that forum. But I actually really like what you were just saying. Like I said, I wrote my way through law school. I'm very tactile in nature. I love a physical book. I've never been able. The only thing digitally I've been able to get into is podcasts in terms of information consumption. Otherwise, physical books, physical paper are sort of my preferred method of reading. So.
Interesting day yesterday, I had at least. I decided I'd read through all of United States versus Rahimi. That is the decision upholding a state's right to restrict a person who's on a domestic restraining order from possessing firearms. And it was an 8-1 decision. The outcome of the decision interested me less than the fact that there was so much reporting on how the court reached it. It was the first post-Bruin decision. In fact, but for Bruin, it would never have reached the Supreme Court. The Fifth Circuit had denied the challenge. And then Bruin talked about the need for a restriction on a Second Amendment right to have rooting in our history and traditions. And Mr. Rahimi's lawyers argued, well, this doesn't. And therefore, placing restrictions of this sort on a citizen's Second Amendment right to possess weapons was wrong. And in the end, it was an 8-1 decision with Clarence Thomas consistently taking the position that unless there's an exact analog, unless you can look back in our nation's history and see that this right was restricted in this manner for these reasons, a contemporary effort to restrict that right, however well-founded it may be in a person's sense of public policy, is wrong. And it was interesting to me to see how the 8 other justices arrived at a decision contrary to Thomas's. Thomas's logic was correct, and maybe that's what we want from a justice, a pure logician. But it seemed to me that Roberts and others took the view that we didn't need to have an exact analog in history to ground a Second Amendment right, but we needed to have things that were analogous and looked close enough to what we were trying to accomplish. And so in the Rahimi is not, as is often the case, happy birthday, Chad. As is often the case in Supreme Court cases, the plaintiffs are not very appealing people. Rahimi, there was a man who had a wife, Rahimi, or a girl. Rahimi was his name. Oh, bang, 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 bang. Rahimi was his name. Oh, I mean, they have a fight one day. He crams her into a car. I think her head gets bounced on the car. Somebody comes to her assistance. He starts shooting. Whether he's shooting at her or the witness, who knows?
The word cram is so funny. You're one of very few people that I hear use that word, and I just got tickled. He crammed her in the car. Sorry.
I'm trying to be diplomatic here, And in the next week or so, he used his gun in any number, and so she gets a qualified domestic restraining order against him, basically saying, and to get one of those, you have to show a judge that you or someone close to you, typically a child, are in imminent risk of harm from another person, physical harm. And so, shooting the gun did it. Cramming her in the car did it. And this order prohibited the man from possessing a weapon, which he continued to use. He shot it at a drug dealer's house. He shot it somewhere else. He shot it. And so he ends up being prosecuted under 922 G8 of the United States Penal Code, and he pulls a federal sentence. But his position post-Bruin is, wait a minute, we have never had a provision that prohibited a person under a domestic order from possessing a weapon, and therefore this is unconstitutional under Bruin. The court, in a series of decisions, said otherwise. Sonia Sotomayor took the extreme sort of liberal view, and it was interesting the way the way the decisions were even organized. The opinion of the court that was written by Chief Justice Roberts and joined by the court for the most part was first, and then Sotomayor's was second. And Sotomayor took a view basically that history is one thing, but contemporary needs are another, and we need to balance. We need to balance history against our contemporary needs. She writes, history has a role to play in Second Amendment analysis, but a rigid adherence to history, particularly history predating the inclusion of women and people of color as full members of the polity, impoverishes constitutional interpretation and hamstrings our democracy. So she sort of takes the view that Cass Sunstein does, that the appropriate means of interpreting the Constitution is with democracy enforcing norms. That is an emerging school of constitutional interpretation that I think is capturing the liberal academy.
Yeah, it's a way of putting it, capturing the liberal academy. I don't necessarily disagree with taking a view that reinforces democracy enforcing norms. But I think that is maybe not the same as reading everything through an extraordinarily DEI stained lens.
Maybe.
And,
it may be, and it may be that the DEI stained lens is the caricature of that view. But I think it's a view that we have to contend with, and I think it's an emerging view of constitutional interpretation, especially in the lower courts.
Norm, so this is something, Montour Wire, thank you for this question. So just to recap on laid back law on Friday, this came up, Norm, this case, and it was very new. So I don't feel like there was anybody on the panel that had even cracked the opinion. And for that reason, I was reluctant to speak very much on it. But this question, I think, is what we were contending with, which is, again, getting to sort of the Me Too movement and the danger of the perversion of this method of depriving people of gun ownership or possession. And I say this meaning domestic violence restraining orders and the sort of dysfunction of the average interpersonal romantic relationship in 2024. And whether, and I think Justice Thomas in particular, Norm, took the view that there was no due process afforded to Mr. Rahimi on the underlying deprivation of his Second Amendment right. The only due process he was afforded, according to the facts, was on the basis of the restraining order itself. And from that perspective, I think we can all very easily make the logical leap to say, well, this has the capacity to be taken advantage of fully, right? By let's say motivated members of a dysfunctional romantic relationship.
I think it will be. I think those of you who practice in urban areas and have experience with domestic restraining orders realize that people seek them for all sorts of reasons. The legal standard, however, is fear of violence. But I think, the politics of the case interested me, Mike, a lot less than the methodology, because I saw
100%.
a story.
I'm sorry to take you off the track there. I just wanted to at least put that context on top of it, that we see that. It's not as if we're ignoring sort of that sort of not pragmatic or more practical, because I think, as you already introduced, Norm, this is the first case that we have that interprets Bruin, which makes it extraordinarily important. So go ahead with the methodology. I think that you are you're on the money for us to actually take some extra time to understand how the court contended with its own precedent in this case.
So, I think I thought Gorsuch, I don't know even how to pronounce his name, Gorsuch's opinion was the most meaningful, because he tried to distance himself from an originalism that would be interpreted in terms of strict contractual analysis. In other words, unless the terms of the contract struck at the time of the founding were directly on point, the Constitution is silent to contemporary needs. And he says, that judges have a particularly difficult job. And let me read some of his language. Discerning what the original meaning of the Constitution is requires, and maybe sometimes be difficult. Asking that question, however, at least keeps judges in their proper lane, seeking to honor the supreme law the people have ordained rather than substituting our will for theirs. And whatever indeterminacy may be associated with seeking to honor the Constitution's original meaning in modern disputes, that path offers surer footing than any other this court has attempted from time to time. Come to this court with arguments from text and history, and we are bound to reason through them as best as we can, as we have today. Allow judges to reign unbounded by those materials, or permit them to extrapolate their own broad new principles from those sources, and no one can have any idea how they might rule. And I thought those were words that every law student and every person interested in the law should heed. Perhaps judges' jobs would be easier if they could simply strike policy balances they prefer, and a principle that the government always wins surely would be simple for judges to apply. And he pointed out that never mind, I've got that wrong. And so I think that what Kavanaugh then went on to write about, and what Roberts relied upon, were aspects of old law that suggested that the community had an interest in assuring that firearms were appropriately used and not misused, the so-called surety laws and affray laws. In other words, if there were a person in a community who were deemed or considered to be dangerous by some legal standard, they could be required to post a surety against their misuse of an item. And if they misused the item, they'd pay the surety, or if they refused to pay the surety, they could be locked up. And so I think the contention is that there were hotheads in every community who were discernible. And if people had concerns about them, they could make application to the court to make sure that this person at least had some prospective limitation on their behavior, so they'd think twice before shooting, perhaps. The affray laws made it an offense to parade around in town displaying weapons in an aggressive and threatening manner that might disturb a community. And this included sabers, swords, guns, and so forth. And so I think
that's fascinating. Yeah. Okay. Sorry. Go ahead.
So I think what the court did was say, and I don't want to sound cynical, but it's going to sound that cynical. This is close enough for government work, and it wasn't close enough for Thomas. And so Thomas stood out to ridicule, saying that, analogy works in the interpretation of history. We don't need an exact replica, because after all, if we had an exact replica, we'd be frozen in time. And we're not frozen in time. We live in a society that is evolving amid current concerns and whatnot. And so I thought, Thomas regarded this as a betrayal of Bruin, and it certainly is a betrayal of Thomas's reading of Bruin. But Thomas is now on a one-man ledge with 8 other people prepared to jump in a different direction. Even Amy Comey Barrett suggests that her commitment to originalism is not quite what Thomas's was. And I think this decision becomes the lead. This case becomes the lead case for constitutional law classes in 2025, I guess, the next school year, when these cases are taught, because it is replete. It's a great decision, takes a few hours to read. It's 105 pages long. I would recommend you find the time, if you can, and you're interested in the law, and check out some of the law review articles, because what we have is
Norm, I'm gonna print it and I want to read it in full. I haven't had the opportunity to do that. I've seen, like you have, the reports. I read Justice Thomas's dissent, obviously, because anytime there's an 8-1 decision, it begs the question of who is down there, right? Who's down there and what are they saying? But I wanted to ask you before we get out of here, is Ketanji Brown Jackson. I read part of an article that said that Ketanji Brown Jackson was, while she kind of, I guess, agreed with Sotomayor about the failures of Bruin, perhaps, but that she said that she would have, Justice Jackson said that she would have actually joined Thomas in his dissent had she been on the court when Bruin was decided. So does that make sense?
I missed that. So,
okay, so that's why. So I think that I want to go and actually in the spirit of what you just said, because I agree with you. it's often the case in law school, especially sort of the doctrinal courses of con law, crim pro, that you are given these sort of landmark cases, and there is a maybe it's an 8-1 decision, maybe it's a 9-0 decision, maybe it's 7-2 or something else. But in the instance where you have everybody needing to concur and write and express themselves in what they believe is a unique way apart from the majority opinion, I think it is worth. And to me, I back up again and just say, 30,000 foot view. I think Bruin is on shaky ground because I don't know that the court is confident in its own ability to interpret the precedent that Bruin set.
Well,
That's
and here's some language from Jackson that I think suggests you're dead right. No one seems to question that history has a role to play in Second Amendment analysis. But per Bruin, courts evaluating a Second Amendment challenge must consider history to the exclusion of all else. This means legislators must locate and produce, and courts must sift through troves of century-old documentation looking for supportive historical evidence. And then she has a meaningful footnote. It's footnote 2. It is not clear what qualifies policymakers or their lawyers who do not ordinarily have the specialized education, knowledge, or training of professional histories to engage in this kind of assessment. And dutiful legislators are not the only stakeholders who are far outside their depth. Bruin also conscripts parties and judges into service as amateur historians, casting about for similar historical circumstances. And, it's a good point, because if you look back at your legal education, and you remember the highly controversial decisions of the Warren Court, they were almost always brief and written in terms that a layperson could understand. This is due process. It ain't fair. And then, the originalists got their hands on constitutional interpretation, and suddenly everyone had to become an amateur historian. There's not a lawyer in 1,000 on the streets of Connecticut who's read Blackstone, all 4 volumes. There is hardly a lawyer in a trial judge, or there's hardly a trial judge who has read the early texts on constitutional interpretations. The Supreme Court justices have become sort of a priestly caste with a scholarly compendium of material that isn't really taught elsewhere. And the result, I don't know what the result is. I think the result is decisions that the rest of us have a hard time understanding, because we have to take on faith so many footnotes. I make friends of mine joke that I nerd out and read too many law review articles, because I'm always trying to figure out, where's all this stuff come from? And so with this Rahimi decision, I intend to take another look at it, Mike. I'm glad you will too, because I think the larger question about Rahimi is wither originalism. What does this decision mean? In Heller and in McDonald, there were comprehensive records about communities' response to firearms violence, and the court said, no, it doesn't accord with what we understand to be the history of the Second Amendment. I think Rahimi suggests that the court is more interested in listening to that contemporary record and is trying to find a way to make it square with originalism. I don't know that they can be squared. And I think this is going to be a very interesting set of discussions in the years to come.
And I agree. My opinion of Bruin, when it first was handed down, and we were talking about this historical framework for the basis for analyzing a Second Amendment restriction on firearms, is that history is inching forward all the time, right? And eventually, Norm, we will run into a period in history that is the current time. And the current time, there is a very divisive view of the sanctity of firearms, right? Yeah. So it is an inherently, I think perhaps the country is just a bit too young to make a legal precedent of historical analysis, right? We are an evolving project here, the republic that we live in. And
as one of the justices said, the Second Amendment is in its infancy in terms of its being interpreted. It's not like the First or the Fourth or the Fifth or the Eighth. We've just begun to interpret it some 270 years into our history.
Yeah.
It's an amazing thing.
We're talking hundreds of years in the future. You could look back and, again, 1776, 1798, 1861. you know, eventually you run into those eras. And we're in an era now that is very divided. There is no sense of realistic pluralism, as you've observed time and time again, Norm. So
Well,
I think that Bruin is inherently flawed for that reason. Our framework for judging history is already flawed, and some of us are unable to even accurately dive into history and determine what the truth actually is of history, right?
and that's Jackson's point. I mean, the first time I've given her props in this podcast. I mean, it's a decision that warrants multiple readings, and I would encourage any of you who care about constitutional law and where it's going to take a look at the Rahimi decision. Yeah, there's a lot of jargon in there, but master the jargon and become part of the conversation, and then ask yourself whether we can have constitutional law without jargon. And I don't know if the answer to that is.
I think we should. We should endeavor. That is a high ambition, I think. But I agree with you. I don't know if it's possible. There is a certain expectation of jargon, I think, among those who would like to be a member of the intellectual elite in the United States, right? There is something about that veneer of intellectual superiority that exists in the halls of the court, especially when it's from a partisan perspective, when it favors a more liberally comprised court.
What is the Supreme Court expected to rule on today? Do we have any idea?
I don't know. I'd be speaking out of my bottom, and that book wouldn't be put in the library there in Ghana.
I broke my butt. I broke my butt by Mike Boyer is now no longer on the Llano County Library.
I broke my hiney is probably how I broke my hiney.
Well, look, if it's something interesting and you've got time this afternoon, you want to crank out a half an hour to publish tomorrow morning, fine. But as I pointed out, I've got a family medical emergency to attend to Wednesday and Friday, and so can't deal with the podcast, at least on a timely basis those days. So we'll certainly see you Thursday, and sorry about that, but life intervenes.
Well, and maybe tomorrow, Norm, if you have a availability, we can, rework or reschedule the time to do it. I don't want to put that pressure on you. I know you've got a day job just as I do, and so you're already taking time away from that to be with your wife. But let's talk offline and see if we can't figure out some alternatives for Wednesday, Friday, if possible. No pressure there. Maybe something on the weekend.
Okay, sounds good. Because
right.
I hate to be silent in sweeps week during the Supreme Court. Damn surgeons every time. They must be woke.
True that. Well, look, 8 a.m. most mornings, Law Pod Daily, right here on the red platform at Law Pod Daily, on the black platform at Law Pod Daily, and over on the green platform, Law and Legitimacy. You can also find us on any podcast platform that you are delivered your podcasts, Apple Podcasts, Spotify, Google Play, Overcast, Audible, wherever you find them. Please, if you are watching this or hearing this from whichever of those platforms, make sure you are subscribed. Make sure you have liked this stream or this particular episode. And if possible, write positive comments, reviews. We would love that of you. And we'd also love for you to tell someone about it. So Norm, we'll talk offline about maybe some flex scheduling for tomorrow, Friday. And if not, we will definitely see everybody on Thursday.
Cool.
All right.
AMF, yo-yo.
See you tomorrow. See you Thursday. Bye.